Good evening, ladies and gentlemen. First of all, thank you very much for braving the weather and coming here early. I think without waiting further, I think we'll just get straight to it. The topic for this evening is witness preparation in international arbitration. The talk will be around 45 minutes to an hour, with a further 20 minutes or so for question and answer at the end for you to address the panel. We have three personalities with us this evening. The talk will be delivered by Claus, Lenz, and Professor Dr. Rouven Bodenheimer, and will be moderated by Sudharsanan Thillainathan. A few words about Sudha before he introduces the topic and our speakers. He's a partner at Shuklin & Bock, and his main practice areas are civil, corporate, and insurance litigation with a focus on complex commercial and corporate disputes and fraud. He is the current Deputy President of the Malaysian Institute of Arbitrators. Without further ado, can we please put our hands together for Mr. Sudha?
Thank you, and good evening. You're not here to listen to me, so I'm going to be very brief. I'm delighted to introduce both Claus, Lenz, and Rouven Bodenheimer, both of whom are leading individuals in the field of international arbitration. And they are here to speak on a very important topic called witness preparation in international arbitration. Both Claus and Rouven have told me don't waste time introducing us. Let me direct your attention to the brochures that were circulated by the KLRCA. Their detailed CV is found there. They're both extremely accomplished gentlemen, and we are delighted to have both of you here with us this evening. So can I, without further ado, invite Professor Rouven to kick off the seminar. Just by way of introduction, the session is going to be divided into three parts. So Professor Rouven is going to start off the session, and then he's going to pass the mic over to Mr. Lenz, and Mr. Lenz will then pass the mic back to Professor Rouven to not so much wrap things up, but to finish the third stage. And then we hope to have a stimulating Q&A. All right, over to you.
Good evening, and thank you very much for these very warm words of welcoming. I must say, and I dare say to speak on behalf of the two of us, it's always a great pleasure being in Kuala Lumpur, being in Malaysia, visiting your beautiful country. We always try, whenever business brings us here to Asia, to combine this with a visit to KL and the KLRCA. And we are specifically happy to being in a position of business having brought the two of us here, so we can jointly talk to you and exchange views. About the background of this topic, first with regards to the timing, I always must think when I'm introduced of by being told that we're going to talk for 45 minutes about a conference which I attended some years ago, and a QC, an English QC, was the chair, and there was another European, much more senior professor from a southern European country. And the QC, he reminded him, he said, don't forget, you know, your time is limited to 45 minutes. So this gentleman, he got very upset and very excited and said, 45 minutes, you know, how can I tell everything I know on this topic, all my wisdom, how can I share it within 45 minutes? So the QC just bent forward and says, well, just speak very slowly. Yeah? So we see how we can manage with our 45 minutes. The background of our today's topic is actually threefolded. There is a very famous case that I think at least everyone in Europe takes notice of, which takes place in Germany. It's a litigation case, the Deutsche Bank case that brought up some of the issues we want to talk to you and with you about. The second is actually recent own practical experiences in arbitration where these questions came up, and I wouldn't dare to say that we found a final solution to the questions we want to share with you. And thirdly, because of this, we strongly believe that it is a fitting topic, as it really, there is no pure and the one truth that we can share with you, but it's a topic that really requires your input and provokes your input and your experience to share as well. Having said that, another comment is, in order that our approach to make it as lively as possible, we'd like to introduce the Chatham House rule, which you are all familiar with. So whatever we are saying when talking about cases, you may not misquote us directly and by name with regard to anything we are sharing with you. What does preparation of a witness mean? I mean, by definition, I'd like to draw a distinction between the formal preparation and the substantial witness preparation. Whereas the formal preparation of a witness pretty much is limited to informing a witness about his or her rights and duties, we have very different levels and intensities of the substantive preparation of a witness. And I don't say that this list is exhaustive, but I think it gives a very good overview of how one can prepare a witness. So the witness interview is pretty much probably the most respectful and defensive way of gathering the information from a witness, by just asking the witness what he can tell you about a certain subject you're considering him to call in the box. A lawyer's lecture, there it gets a little bit more trickier already, is the concept where the lawyer actually elaborates the different legal impacts on certain testimony to be given, the consequences, and potentially legal requirements about certain situations and the impact on a case, so that the witness might draw certain conclusions about what he is going to say or what he's considering to say. The rehearsal as such is a preparation where you indeed exercise with the witness Q&A, and you'd also discuss probably about different options and different answers that could be given. A mock trial is similar. You do it in a realistic situation. So probably you have the bench, you have 3 arbitrators sitting there. You have in the US, that would exist, you have a jury there. So the witness is not only prepared to the certain answers, but the entire situation with interruptions and interventions from others but the lawyer who's going to examine the witness. And then certainly the most intense form of witness preparation, I call it the group preparation. So this is the situation where you really make sure that all the witnesses you're going to call will give evidence in line with each other. You confront the witness up front with what other witnesses have said. You probably even introduce to the witness what would be favorable for the outcome of your case in order to witness. To which extent this is permissible and to which extent it is used is indeed the question we want to discuss. And the good starting point actually is the German bank case, where these questions came up within the German context. And by saying this, I pass over to Claus and would like to show a very short video sequence which outlines the frame of this case. Shall I do anything?
According to a report in the newspaper Die Welt, Deutsche Bank will seek compensation from former chief executive Rolf Breuer for a costly out-of-court settlement reached earlier this year with the heirs of the Kirsch media empire. The bank's supervisory board this week decided to seek compensation from Breuer, the newspaper reported, adding that the bank still expected to pay most of the settlement itself. The large part of the settlement will definitely stay stuck with the bank, the paper said, quoting a person familiar with the supervisory board discussions. A Deutsche Bank spokesman declined to comment on the report, and attempts to contact a spokesman for Breuer himself were unsuccessful. Deutsche Bank needs to seek compensation from Breuer before so-called directors' and officers' liability insurance can play a role in covering some of the settlement charges.
The Yes, the Deutsche Bank case is a very important case. It's an old case. We have to go back. There's, I think, a typing error there. It goes back to the year 2002. On the 4th of February 2002, the CEO of Deutsche Bank gave a fatal interview in German TV, talking about a client of Deutsche Bank, which was the Kirch Media Group. And the Kirch Media Group was really a media giant, owning several TV stations and other means of media, built by Leo Kirch for a long time. In that interview, Mr. Breuer said that the financial institutions were aware of the difficulties of the Kirch Media Group, and basically he challenged the creditworthiness of the group. This, of course, triggered a major reaction by the markets, and of course the Kirch Media Group had some financial problems, but these intensified then following the interview, and basically a couple of months later they went into insolvency. So this triggered legal proceedings by Leo Kirch, the owner, and the various companies belonging to the Kirch Group against Deutsche Bank and Mr. Breuer personally. They started in 2002. And it dragged on for more than 10 years. Basically, the question was that the argument Leo Kirch used was that due to that interview, the group became insolvent, and the interview was given as an attempt, a part of a plan of Deutsche Bank to put pressure on Kirch in order to obtain a mandate for Deutsche Bank to do the financial restructuring of the group. They did not get the mandate, but they triggered the insolvency insofar. And that was the course why Leo Kirch then asked for damages. And after 10 years, basically, the Court of Appeal in Munich decided that Deutsche Bank is obliged to pay damages at an amount still to be determined, and this was then ongoing in proceedings. Deutsche Bank appealed against this, but still the case was going on. And during the ongoing case, then in March 2013, the Court of Appeal in Munich, in a court order, expressed its opinion that executives of the Deutsche Bank, CEOs, former CEOs, had lied to the court in denying that there was any plan to lure a new mandate to Deutsche Bank, which was seemed to be very exciting and lucrative. The case, basically, Leo Kirch did not survive the end of the case. He died in 2011, but the heirs of Leo Kirch then continued the proceedings, and they entered into a settlement with Deutsche Bank for 925 million euros. And you would think then, basically, the case is then over. A final settlement, everybody might be happy, can live with it. But based on the expression of the court in that order in March 2013, the Munich prosecutor then decided to investigate in the question whether the executives of Deutsche Bank lied to the court. And so they raided the Deutsche Bank headquarters, and they also raided the offices of two very famous German law firms. It's all in the press, therefore I can tell you it was Hengeler Müller in Frankfurt and Gleis Lutz in Munich, where the lawyers were sitting who advised German Bank in this case. And what they found out when they had raided the offices is that when Mr. Breuer in particular, but also the other executives, had to appear as witnesses in the main proceedings of Kirch against Deutsche Bank, they were to a certain extent prepared for their witness statements. documents were found that saying that the legal department arranged a meeting prior to the hearing of the witnesses in court with the outside counsels. Basically, one document was found where an agenda for the meeting was mentioned, and the agenda had basically 3 topics. It said meeting and discussion with Dr. Breuer, the overall the overall procedure regarding the witness hearing, and the third one was storyline, was called storyline. And the prosecutor also found some other documents where basically the legal department had made a circular to outside counsel and saying we need to prepare the witnesses properly for the hearing in court. And the outside lawyers had sent a letter then to the witnesses and to the Deutsche Bank legal department, basically with a list of proposed answers to potential questions. And that is basically, that leads us to the topic. But coming back to the case for the time being, those investigations were done against 5 led to basically the opening of criminal proceedings against 5 executives of Deutsche Bank. The investigations against the outside lawyers involved are still going on. It's not decided yet whether this will lead to a criminal case as well, but they are now facing criminal charges for attempted fraud, which bears a sentence of maximum 10 years in jail. And the attempted fraud was, of course, lying on the material side, that there was no plan to obtain that lucrative mandate. But on the other hand, there's the side aspect, and this is what we assume that we can take from these hearings in these proceedings. What was the case behind, and how were the witnesses prepared before being heard in the court? So the decision will be basically on the material side whether the witnesses lied to the court. But on the other hand, we hope that the proceedings will get us some more light in the facts, how they were prepared, whether there was a mock trial. What we know from the documents so far, it appears mock trial was mentioned in one paper. We have that catalog of the questions which were pre-drafted by the lawyers. All these things, and the first hearing was in April this year, and one of the former CEOs, Josef Ackermann, very famous guy who was CEO for Deutsche Bank 10 years after Mr. Breuer, who had to resign after this incident, and he already stated in the hearing, I couldn't really recall what happened back in 2002, but the lawyers prepared the case for me, and I had only 20 minutes to look into the papers they have prepared, and then I had to testify before the court. So this is a strong indication that there was some kind of, and that's the big question, influence. So we don't know exactly in which category Rouven had introduced us to this case falls, but we hope that by deciding in the criminal case on the charges on the attempted court, that the court will give us some directions also with regard to witness preparations, what is allowed and what is allowed preparation, the interview or whatsoever, or what the court considers as not acceptable and basically influencing the witnesses and what they should say, maybe against their own recollection. And we are waiting for that. This will be, of course, the commercial side of the case is the most important, but this will be a very important side effect, and we are anxious to hear from the court. Hopefully they will say something in order to define our understanding also for the lawyers, how should we handle the cases. And the lawyers have been acting for the 2 very reputable German firms are fearing, of course, to be subject to further criminal charges and disciplinary measures of the bars, which are still going on. Also, the bar is investigating in their conduct, and we have to wait for the outcome. But this is the case I wanted to highlight to you.
So, don't be afraid. We're not preparing you for the theoretical concept of ever initiating state court proceedings in Germany. We're well aware that the topic is arbitration. But this is indeed, one frame which we got started off, and therefore also allow us, you will see, or I dare say you hopefully will see, that what I'm sharing with you with regard to Germany is probably not only limited to Germany, but allow us to get started there. And the interesting thing is when you deal with witness preparation in Germany, for example, that there are no explicit rules about witness preparation. You have actually very, very fundamental and very broad framework regulations, which you can find in the procedural statute of procedural law. And this is that you must tell the truth. One could spend one day about this provision as such. So as a lawyer in Germany, you have no obligations towards the court. As I understand, you do have in common law systems, haven't you? There is the duty of truth towards the court. You don't have it. So you may even plead arguments where you in severe doubt about its truthfulness, unless you positively know that it's a lie. This is the only limit which you may not threshold pass in order to infringe your professional duties. And then you have some regulations about how the procedure as such is going on. In Germany, the judge or the bench starts to question the witness. Party counsel can then always ask for the entitlement to ask questions as well. But when you look further down the road, we find one interesting provision, and that is that a witness is explicitly allowed to bring in notes. I think that's worth to mention. You are allowed to bring your notebook or your notes and say, this is a long time ago that it happened. I had some notes. I want to have them in front of me. That and easy is my recollection. Legitimate in German courts. The only boundaries are actually very severe ones. These are criminal limitations. So you may not. The one is the attempt of fraud. Yeah, if you lie to the court in order to achieve an economical result in the favor of your party or the party you have an interest in. And the other is that you may not explicitly give wrong testimony. Claus has elaborated on it. Nothing more we find about the question to which extent can we prepare a witness before court. It goes on that even if you look in the professional conduct rules, there are no such provisions. We don't find an answer to the question to which extent can I prepare someone. Again, only very rural provisions which you might draw into the room in order to argue in the one or the other direction. You are obliged to act professionally and to properly represent the profession of the bar, full stop. And there's a principle, I tried to translate it with objectivity. That means you may not make any personal or improper comments, statements, or moves in proceedings, full stop. So the answer then would be probably you can go to the farthest extent as long as you do not invite your witness to lie. How is it in other nations? In the United States, it is totally different. And there you see where we're heading to when we're approaching the topic and the field of international arbitration. In many states in the US, as probably you are aware of, there is exactly the opposite. There's a duty to train and prepare your witness properly. Otherwise, you face actually a claim for damages for improper behavior and improper conduct of the proceedings to represent your clients. England and Wales, and allow me to say this from the outset, it is not us to lecture you in any sense on common law and English law. So the experts in this regard are you. But I'm happy to get corrected on this. Witness coaching as such is forbidden. In England, you have an additional aspect of complexity, which is the split profession between barristers and solicitors. Barristers are subject to different professional rules. They might even less communicate with witnesses in advance than solicitors are allowed to do so. And my understanding is that indeed mock trials are allowed, probably not by the barrister who will appear in court for you, and under the additional requirement that this mock trial may not be linked to the actual case as such. So it may serve the purpose of preparing a witness of the entire atmosphere and what can happen, but it may not aim at actually improving the testimony in this specific case. Interestingly, in Europe you have several countries where a witness preparation as such is entirely forbidden. You may not communicate with a witness before, not even to say of a rehearsal or a witness coaching. In other countries, again, it is similar like in Germany. There are no specific rules on whether witness preparation is allowed, and if yes, to which extent. So the question indeed now is, on this basis, what do we get out of this frame on these regulations dealing with the conduct in national court proceedings for the scene of international arbitration? And I think there are two sides of the coin, and you can find two different views in literature, and if you probably even talk with practitioners. And the one is that says, even if you are prevented from certain preparatory steps under national law, such laws shall not apply in international arbitration. So even you are bound by your national rules in front of a court, you are not so if it is in arbitration. The opposite opinion is, of course, to say either you're a lawyer or you're not a lawyer. If you're a lawyer and if you're bound by your code of conduct and your professional regulations, then this applies in any situation where you appear as lawyer and render legal advice and perform lawyer's duties. So this is also reflected, interestingly, in some national rules. The Swiss, for example, they, in their civil code, on the one hand, prohibit any witness preparation, but explicitly exempt any lawyer's work in international arbitration. So what they consider as ethically correct in their state courts. The Swiss are also very good businessmen. They know that this would be detrimental to the seat of Switzerland as an arbitration hub, and therefore they explicitly allow, and you can also read in the reasoning of the lawmaker, that this is an economical consideration that has driven to this decision, by opening up in international arbitration. A different approach has been taken on a European-wide level. There is a so-called Code of Conduct for European lawyers of the Council of Bars and Law Societies of Europe. And there, this says pretty much every lawyer is bound by the national regulations he's subject to under the bar or the law society he's admitted under. And the same applies when acting in an arbitration or any third party who is deciding a case. This is not binding, it's just an indication of how to deal with that. So on this basis, I want to share one case which we experienced as counsel, representing an English-German joint venture in an arbitration, ad hoc arbitration against an Italian company being represented by Italian lawyers. We initiate the claim, representing claimant, and at one point it comes closer to the hearing. The arbitral tribunal requests witness statements as a quite natural measure of efficiency. And suddenly this Italian gentleman, the legal counsel comes out and says, no, I can't make any, I can't prepare witness statements. So why can't you prepare witness? He said, I'm prevented from liaising with the witness up front. So you can imagine, he said, and by the way, I also request the arbitral tribunal to order claimant's counsel to refrain from drafting any witness statements for their witnesses, because otherwise this would be an extremely unfair treatment in these proceedings if claimant could draft witness statements, liaising with its witnesses, and I couldn't. So I don't want to tell you, because I don't think there's a truth or the one answer. I don't want to share with you how we reacted, but the question is indeed, how would you have reacted being counsel of our party? How would you have decided or reacted as sitting as arbitrator in this dispute? So let me just quickly make a side note, which I think comes up from time to time as well, and this is the issue of remuneration for witness testimony. The starting point, I think, is that in contrast to state court proceedings, in arbitration, there is no duty to give evidence. Yeah, we all know that there are national provisions and international provisions. You can always seek state court assistance to get a witness in front of an arbitral tribunal, but we also agree this is quite difficult, and I dare say probably not many of us have experienced such a maneuver, without saying it's impossible. So I think the legitimate question already with regard to arbitration is, does remuneration increase probably the motivation to testify for a witness who is very often a businessman who has better things to do than flying somewhere and give evidence to something where he has no interest at all in anymore? So, interestingly, I just present these two US cases to you. There's one from the 90s, it's Golden Door Jewelry and Lloyd's. There, the insurer, who was the defendant, offered $120,000 US to any witness testifying the full truth. That's the offer. Yeah? Testify the full truth, and you get $120,000 US. In the second case, Wagner and Lehman Brothers, the lawyer himself, he offered a percentage of the money claimed in case the case was successful, and of course under the condition that the witness would tell the full truth and nothing but the truth. 15% to the witness. How were these cases decided? In the first case, this was related to depositions. All depositions that were taken on this basis were excluded and not considered. In the second case, the former colleague is not one anymore. He lost his admission over this case. So, but again, getting back to arbitration, for our discussion later, it's my opinion. I say the starting point is, in arbitration, what is not forbidden is permitted. You can pay a witness. Why shouldn't you? Exactly for these reasons. And I go further, how do you deal then with this in practice? It's just, and I think also this is nothing new to you, it's established practice that you ask these questions to a witness. Either at the latest it will be done by opposing counsel, but in many instances it will already be done by the arbitral tribunal. To say, have you been paid for giving evidence here today? Have you been paid for appearing today in front of us? And a practical consideration is, if you pay, and if you follow the approach that this is legitimate in principle, on the basis that you must say, if there is a businessman and he could sell his time otherwise, when not appearing in front of the arbitral tribunal, why shouldn't it be fair and equitable to pay exactly these costs? What is important is, I think, just as a practical consideration is to ensure that you make these payments unconditional in advance and do not agree on any terms where you say, we first see how you perform and then you get something, of course, only based on the fact that you will tell the whole truth. And there, just another case example, it's, as I said, I think we all have experienced a situation where a witness is asked whether he has been paid for giving evidence. And I think a good rule of thumb is just like, what could you have earned otherwise? But in my times when I was working in London, we had a case in a hearing. Exactly this case came up and said, yeah, it was like a former mid-level employee of opposing party. So, and in cross actually, he was asked, so did you get paid? Yeah, he said, I get paid. So on what basis did you pay? He said, well, I only got paid my expenses, normal costs. So I said, how much is it? And then there was silence, and then he said, it was actually £15,000 a day. So there was end of cross-examination. He said, no further questions, thank you very much. You know? So don't be too generous when paying witnesses. These are, as you've seen probably, I think, totally different approaches within different national regulations. How is it on the international scene? And there, as always, everyone who has been here in December where I talked knows that I'm not a great fan and supporter of all these guidelines and rules which are coming up, but they always serve one good purpose, and this is, I think, one can illustrate a certain approach. And having a look at the IBA rules on the taking of evidence, as well as on the guidelines on party representation, we can state that it appears, at least under these rules and guidelines, it is not improper to liaise with witnesses or potential witnesses in advance and exchange also even views with them. I personally say, you don't see, when looking into these guidelines and rules, what is the international standard, but I dare say you see that the Americans in the drafting group had a very powerful influence there, because they wanted to ensure that their ordinary common practice is not permitted under these rules and standards on an international level. When looking in institutional rules, I think one can say that you have very, very few sets of institutional rules which deal with this topic. The KLRCA rules do deal with it, saying it shall not be improper for any party or its legal representatives to interview any potential witness for the purpose of presenting his or her testimony in written form or producing such person as an oral witness at any hearing. And of course there's a limitation, so the legal representative should not knowingly procure or assist in the preparation of or rely upon any false evidence presented. You have similar rules in the SIAC rules, and I'm happy that Sundra is here with us, because the only rule that I found that somehow deal with it is 28.2, and of course I only put it here because I would say the heading is hearing. It does not cover the question of to which extent can you prepare a witness under the rules, but maybe Sundra explains us that it should be interpreted in a very broad term and also covers any steps before the hearing takes place. So, as promised, leaving enough room for a lively discussion, let me come closer to an end of our presentation. What are the limitations to witness preparations? For sure, what is the common ground? Partly, there is no limitation in procedural laws or in the Code of Professional Conduct, and partly in some national regulations you have such provisions. What is, I think, indeed absolutely common among any nation, any judicial system, is you may not provoke or create a falsification of witness testimony, and the frame is always the criminal law. Whenever you overstep this threshold, you are in trouble, and this is certainly sanctioned. So, what are our conclusions? I think in general, international arbitration acknowledges the admissibility of witness preparation. Witness testimony, which is obviously trained and therefore probably lacking credibility, can be countered by exactly an evaluation and an assessment afterwards by the arbitral tribunal of the witness, of the testimony that has been submitted to them. Again, also in international arbitration, falsification of witness testimony is the limit. And it gets interesting, and I think sometimes, as the Italian case just indicates, as this is something where we do not have a lot of rules about, the arbitral tribunal, at least probably also the council, just must ensure that the parties and their representatives stick to the same set of rules, whatever that might be. Having said that, I can only conclude by saying, hopefully you're not as exhausted as these gentlemen, and thank you very much for listening to us.
Well, thank you very, very much to Claus and Rouven for that very clear and illuminating presentation, delivered in typical German style, efficient and clinical. Well, we are ready for a lively discussion. Certainly, Claus and Rouven here both are looking forward to a lively discussion. Yes, can I invite you to introduce yourself? We all know who you are, but Claus and Rouven may be meeting you for the first time. So can I invite you all to introduce yourselves? Just say where you're from and pose your question. Thank you.
My name is Thillainathan. I'm a lawyer also. Okay. I just got one question. Regarding witness statements, there's sometimes a very gray area where the solicitor will try and, I won't say coach, induce his witness against self-incrimination. In a sense, he will not tell the truth or not tell a lie. He just circuits the entire question and to protect himself, to protect his interests. He's not really telling a lie. Neither is he really telling the truth. He knows something, he doesn't want to say it. And the lawyer will try and craft the particular witness statement in such a way that he doesn't incriminate himself. Now, that kind of question, how would you answer that? Against self-incrimination.
I think the limit is really whether you falsify or whether you say the truth. But you are not obliged to tell everything you know. So you could leave out something which is detrimental and definitely something which is against yourself. But we don't think that is the privilege of the counsel to ask further questions to the witness and try to figure out whether there is more, or whether he's aware of more facts or so. But we would say that he's not obliged to tell the entire story. But you have to be careful when you be very selective, and let's say there is a number of facts, and 28 facts are against you and two are in your favor, that you just limit yourself to the two. That becomes then difficult.
Any other questions? Mr. Koo.
Cool. I'm arbitrator. I think under the, to sort of comment on the asked question about self-incrimination, I think many years ago, the Evidence Act says that a witness may be excused for answering questions if it is going to result in self-incrimination. But I think some years back, I can't remember when, that provision in the Evidence Act has been amended. And now a witness in court must answer questions even if it's self-incriminating, but he shall not be prosecuted for that. That evidence he gives will not be used as evidence to prosecute him if it's self-incriminating. I think that is the current position on the Evidence Act, if I'm not mistaken. But we also know that Section 2 of the Evidence Act says the Evidence Act does not apply to arbitrations. So witnesses in arbitrations will have to be very careful that they may be prosecuted if they give any self-incriminating evidence. I don't know. It's not been tested.
It's just a comment on this. I think this triggers another topic to discuss, doesn't it? And this is the question, the balance between the confidentiality of arbitral proceedings on the one hand, and at a certain level the duty of probably persons involved, and foremost the members of the arbitral tribunal, of disclosing probably crimes that the arbitral tribunal becomes aware of. And I think this is a very big grey area. It most often, in my experience, happens. It regularly happens, but not probably with the one gentleman who confesses that he has committed a murder. But for example, with regard to anti-competition issues, yeah, which you normally would have to go after. And the question is, do you have to reveal them, or are you bound by the confidentiality? Same applies there. And then I think, if you then switch to counsel side, to which extent can you advise someone to take a risk to say, you can disclose this here because it can't be used outside, yeah, helping your own party?
Hello, my name's Isaac. Actually, I just wanted to find out a little bit more about the Deutsche Bank case. There you said that, what they call the lawyer, the banker has actually made a statement in public that caused a certain client of his to go down. But the question is, is he saying the truth? If he is saying the truth, why should he be punished? That's the one question, because it actually is saying the truth, unless he's lying, So that's one. And also, of course, you said that in civil law you really don't need to tell the truth, and whether that is really applicable to arbitration. In arbitration, I think predominantly people are looking for the truth. If you're talking about construction, I'm talking from construction aspect. People do want to find out the truth. So I think if the truth is hidden and then the arbitrator actually knows something, wouldn't the whole focus be actually to look for the truth and not to hide or leave the truth away? Yeah, thank you.
Maybe I answer to the first question. Even if he said expressed the truth, but in his capacity as the CEO of Deutsche Bank, in a situation where this group had financial difficulties, but was basically in a situation where with a financial restructuring it could have been saved, he could not mention that basically the financial circles would know that they are not creditworthy anymore. And it was their own clients to a certain extent. And that created basically the whole group to tumble into insolvency. And that was the critical part of it. He should have clearly abstained from that. So insofar that they were not creditworthy anymore was also not true in that respect, because indeed, and basically documents were found that the board of Deutsche Bank had discussed about the possibility of a financial restructuring of the group, and of course this was not decided at that point of time, whether this is still possible or not. But basically that gave the last shot to the group. Basically they were dead after that, and it took only 2 or 3 months before they had to file for insolvency.
I'm very grateful for this second question, because the question of truth is something I have to think about very often. And let me start by a very big compliment. Being a civil lawyer, but having worked quite some time in a common law jurisdiction, I think
the common law system is absolutely superior when it is about finding truth. The way the common law system is set up, the procedure, disclosure, examination in chief, cross-examination, and so on, are the ideal tools of bringing the truth to light. And a civil law system is not capable in the same means of doing that. But bringing up the truth is, as we know, is a very costly venture and a very lengthy lecture, as you can see by all statistics and everyone who has experienced or has experienced 1,000 court cases in Germany and in England. This is the requirement for making statistical statements. We'll see that the civil law system is more efficient, lacking probably truth. And then I just ask you back, is it really true that all parties in construction or any other sense, is it really true that commercial parties aim at truth? In the very end, they aim at economical, feasible results. And probably if you look at 1,000 cases, I dare say probably parties can live much better without having found the truth always, but with efficient, quick, economical, valid results. And then on top, we could open another discussion by saying the truth is a rather relative term, isn't it? So in the end, even if I made this big compliment to the common law system, I don't know whether you always, what you find in the very end, whether it is always the truth, or just the result of the masterpiece of very experienced QC.
It's interesting, because coming from a common law situation, we will have hearings that go on for months, years, and then eventually, you get an answer. Sometimes the answer is satisfactory, sometimes it's not satisfactory. It depends how the answer is done. If it's a lengthy answer dealing with all the evidence and all these things, it could be satisfactory, but the interpretation could be challenged. But I cite an experience in doing a CTEC arbitration where the parties did not, Malaysian party came up with witnesses, the Chinese party did not have witnesses, so I was really quite puzzled. I asked my co-arbitrator, the chair, and I asked him, he was from Hong Kong, a barrister, but very fluent with the civil law system, but he was a common law barrister. And he told me, the Chinese have an attitude towards witnesses. They all lie. So basically, there's no point having any witnesses because the tribunal will not actually regard whatever evidence they give. I think that's the other extreme. And I suppose, I think they have some element of truth is that you live and die with the documents that you have. If you can actually show the chronology and the transaction that goes in the documents itself, that itself should be sufficient to answer this, which is a very civil law way of approach. That is fine. So I think truth for them is what you have, that you can show. The second thing is that my experience in sitting as in construction arbitrations is that the key witnesses are normally professionals. You have the architect, you have the engineer, you have the quantity surveyor, and they sometimes, and even on the contractor's side, they will be professional people. And of course, they move after they finish the job. Once the arbitration starts, normally the job is over. They all have gone off to other lives, So to call them back to do the thing sometimes is quite a difficult thing. And many a times in the arbitration, the witness will be asked, let's say he's an architect now, are you being paid to come here to testify? Direct question like that. And he will, he said, yes, I'm being paid. And what are you being paid? And it goes on and on. But I think that it has to come to a time that we may have to deal with it. For a professional person who actually comes to give evidence, his expenses should actually be considered. Because the time sometimes in construction arbitrations, they can spend, especially in Malaysia, an architect, let's say being cross-examined, he can spend 10 days in the witness box. 10 days of his life, and he has to prepare before
and then go back and re-look and look at the documents and relive his entire process of certifying. Normally what he does is whatever he has done, he has to relive it and explain and justify. So I think, what are your thoughts on that?
Maybe again to the first thoughts, I think the civil law systems, they rather go for a relevance threshold. That means when we prepare hearings, we first of all find out, whether we need the witnesses at all. And if you say, if you have documentary evidence on something, we might not need the witnesses. And if a party nominates 30 witnesses, then we rule it out and say we don't need to hear them, What shall they say otherwise than we have already on paper? Or somebody's offering 5 witnesses for the same fact, It might be sufficient to hear one of them. And then you also have to cut them short if they then turn to other things which are not relevant for deciding the case. And I think that's the downside of the common law. You try to explore each and everything, and the Americans are even worse in that. Yeah, they want to go into every detail, whether it's relevant or not. So I just experienced in an ICC arbitration where one party is represented by American lawyers, that they requested, and the claimant is a European party, and they challenged already the statement of claim because not each and every fact which was mentioned in the statement of claim was supported by witness statements. And I told them, hey guys, be a little bit careful, We don't know how you respond to the statement of claim. We don't know what you admit and what you are challenging. And only once we know what is challenged, then we find out whether it's relevant, and then we might hear a witness. So I don't need 30 witness statements to start with. This was very difficult to get across to the American lawyers. You might touch the cost.
Yeah. No, I don't know whether you came in a little bit later, but I would absolutely agree with you to say that the fact that you pay a witness, not only travel expenses, but also actual costs, to say, you keep someone indeed, locked up in a room for 10 days of his life. Of course, this gentleman must be compensated if he could earn money otherwise. I would always expect an arbitral tribunal to credit for that. And the example I just gave is, you may just probably not, incentivize this witness by offering him the double, triple, or whatsoever amount he would normally earn, beyond any reasonable ability to understand. But so the other point which you said, I think, is we talked about, or we conveyed, probably tried to draw a picture of witness preparation, which tends to be bad. And what we haven't talked about is that I think also in reality there are a lot of situations where I strongly believe that this is for the good, for the truth, to do so, because you have probably a witness, Sundar, you just mentioned it, which is just a professional witness. This gentleman is in the business for 30 years. He has experienced 20 arbitrations, witnessed 20 times, and doing actually every day of his life nothing else than professionally commenting on whatever. And then you have someone who's very reliable, who really tells the truth, who knows the truth, who is a key witness, but from his professional background, his experience, his personality, there's a big danger that opposing counsel might destroy this gentleman or this lady, her or his credibility, just because of the superior power that is given to counsel, especially in a common law system. And the question is, how can you actually counterfight this? How can you help the truth to come out? And I think this is a situation where you desperately need to prepare such a witness in order to make sure that what he or she has to say and could say without pressure will also survive the pressure you have at hand. And then you are much more experienced on this, but again, during my time in London, I dealt with these questions, and I think these are very actual questions which come up foremost with regard to vulnerable witnesses. What about children? All these abuse cases which I'm not dealing with, but where you have situations where the experienced counsel can destroy such a witness and actually take away the light and the truth, just because the procedural provisions allow him to do so.
Any other questions? Yes, please.
I got two questions really. Earlier on the Deutsche Bank case, you mentioned that the lawyers also were under investigation. I want to know on what aspect were they under investigation, generally, so to speak. And the second question is regarding the, you mentioned the fact that when you talk of construction law, construction cases, it's more prudent to go to stress on economic viability. So if that is a possibility, how far does it dilute the burden of proof of balance of probabilities? How far would that dilute it? And do you need to have balance of probabilities to prove something if you look at economic viability? These are my two questions.
Again, I start with the first one, the Deutsche Bank case. Yes, if the lawyers have basically pre-formulated the answers against what the recollection of the witnesses were, and they have been sitting together and sitting with 5 executives and saying, come on, we have to form a line, you know, what they expressed in storyline. So we have to make up a story that it all is in line with what you say and what you say. And then they are helping the attempted fraud, and they would be subject to criminal offense as well. So since we don't know all the facts so far, which might be revealed in the case now, they still have to fear that somebody's going after them as well, because then they are helping in the attempted fraud.
Well, just very brief, I think the question of efficiency or the conduct of the proceedings has in principle no impact on the burden of proof question. That will be my answer to this. And in practice, I could add that sitting as an arbitrator and having experienced a common law driven proceedings, I sometimes more than once have experienced that parties say, yeah, and then we want to submit on this aspect, and then we want to submit on this aspect. And depending on whether the tribunal was courageous enough and probably civil law driven, they have said, no, you don't need, we're not interested in, because it's not your burden of proof, yeah? If you remain silent, everything is fine for you. First, the other side would have to substantiate something on this aspect, and then we might want to hear you. Whereas I've seen a lot of waste of money and time where the arbitral tribunal just remains silent and say, okay, you're in the driver's seat. If you insist on arguing on this point, please have a say, and then at the very end of the proceedings, we will write down this was never relevant for us. Yeah? No.
I'm going to ask a question. Rouven, you said that there are 2 schools of thought. National laws either apply in the context of international arbitration or they don't. And then you drew our attention to the IBA rules on that subject. And you mentioned the Italian case. And I think you told us what the outcome of the Italian case was. You didn't. Why don't you tell us what the outcome of the Italian case was first before I pose my next question?
Well, in this case...
Would you like to just remind them perhaps about the issue in the Italian case?
Yeah, you remember the Italian gentleman comes in the middle of the proceedings, short before the hearing, and says, witness statements, what is this? I'm not allowed to do something like this. I can't do it under my national rules. And by the way, I request the other party, which was me, to refrain from interviewing the witnesses in advance as well. So. And because otherwise, and then they always bring these very dramatic guns in the room, at least for the arbitrators, they say, yeah, because otherwise we are afraid, that the equal treatment of both parties, have a look in the New York Convention, yeah, Article 5, we will raise this point because we're treated unfairly. And we also must remind you, because obviously my initial reaction was, literally, I said, yeah, fine, if you have a problem with it, then just get lost and you guy get a new counsel in the room. Yeah, and then they said, yeah, but this is also our fundamental right, yeah, the free choice of counsel. It's accepted principle in arbitration. We can choose whomever we want So, and as I said, our main line of argumentation, to make it short, was pretty much to say we're not playing in Italy. It was also, there's another question which you might want to address afterwards. The seat was not Italy. So we said with our utmost respect, we just don't care, get lost, yeah? It's the party's free choice to choose a council you want to, and if you choose a weirdo who is not entitled to comply to international accepted standards, then it's your problem. Get another one or live with it. No, seriously, and I strongly believe in that, because exactly this free right to choose a council, in the very end, I'd say, very pragmatic, it's not a problem of international arbitration, it's not a problem of these proceedings, it's not a problem of equal treatment, it's just an economical problem of the bar standards and regulations for Italian lawyers, full stop, yeah? And you have a free right to choose someone. You could even appoint my mother as counsel, couldn't you? In arbitration, you do not have to be represented by a lawyer. My mom is a dentist, so I don't know whether she helps you, but you could appoint her. And therefore, and this was our line of argumentation, and luckily, the arbitral tribunal agreed to us and said, and another point is, and this I think is relevant, and this is why I quoted this case, it was too late to bring this up to the table. And then I think when we go one step backwards and have a look at it, that's, I think, the most interesting question. I dare say, and please correct me, this is an issue where we very often lack a sense for this upcoming problem. Yeah, because of course, how can we be aware what an Italian lawyer is subject to under its national laws? And it probably starts earlier, and there are other issues which we all have experienced. Yeah, the approach of an English qualified lawyer against a German lawyer, or even more extreme for my perception, an American lawyer and the German one. But to solve this and to avoid problems is to have a sense for it, either as counsel but even more as an arbitrator, and address these issues at an early stage. Because it gets very tricky. There is no rules that you can just rely on, and the IBA guidelines and the IBA rules also, I would always raise this argument, must be specifically agreed between the parties if you want to get anything out of this. Yeah? And I would object by saying, yeah, but this is an internationally accepted standard. Who says that? Yeah?
So basically you have the chance as an arbitrator to put this in, when you have ICC arbitrations, in the terms of reference, whether you agree on certain standards of taking evidence and how you deal with it, or you do it in a procedural order after having heard the parties. But you have to be aware of that potential problem, and basically it should be in the checklist of every arbitrator when he's sitting, you know, how do I start the proceedings, how do I want to guide the proceedings? That should be one topic on the checklist.
Any other questions? Yes, please.
Rouven, I was rather surprised, Roderick Noble of 39 Essex Chambers, I was rather surprised to see that one of your headings was that falsification is the limit, or the limit is falsification. So does that mean anything short of deliberate falsification, which leads to the tribunal being deliberately misled, is okay?
If you don't, I'm always a little afraid when Rod starts a question by saying he was surprised, you know. Allow me to just make this comment. When my professor, where I did my PhD, he told us, I think still today, a very entertaining story about our limited ability of speaking English. And he told the story of Mr. Webster, which you are all aware of, the guy who issued the dictionary. So Mr. Webster is sitting in his office with his secretary on his lap. And suddenly the door opens and his wife enters. And she says, "Oh, I am surprised." And Mr. Webster replies, "No, you are not. You are astonished. It's us who are surprised." So, luckily I forgot your question about the sorry. No, falsification. Yeah, well, I mean, like, allow me indeed to counter-ask, if you consciously mislead the tribunal, what else have you done at a stage prior to rendering the award than a falsification of a statement?
Well, you might omit relevant evidence, as I think Claus suggested, that by omission you could be deliberately misleading the tribunal. Are you entitled to do that?
Yes, you're absolutely entitled to omit anything that is adverse to your party. And if you're addressed and if you're asked about it, then you may not tell a lie. But you must not present anything that is adverse to your party. And Rod, you're the right guy to ask back. Everyone from England always says, yeah, it's really amazing, our system is aiming so much at the truth. For example, every barrister will say then, we are obliged towards the court to even quote and cite jurisdiction and cases precedents that are adverse to our party. Gentlemen, you are all much better trained in the common law than I am, but how often do you really experience such a performance of a counsel?
Certainly in the UK, and certainly in the English courts, counsel has a duty to draw the court's attention to any case that is against his own interests. But let me give you a crass example. Supposing you're making a claim on an insurance policy for a ship that sank, are you entitled to admit that you know that in fact that ship sank because it was scuttled? It would make a very significant difference to your claim.
Yeah, but okay. Thank you for giving this example, because it probably sheds more light to the situation in Germany. It's not a barbarian state. We have a Bavarian state, but not a barbarian one. Of course, this would be a constellation where you positively know, or make it even more drastic. Your client asks you to claim compensation for a lost vessel, which is not lost at all. It's just, in some African harbor, wherever, and you know about this. Of course, then you may not plead this thing. But if you do not positively know that the vessel still exists, but you personally think it still exists, the duty towards your client prevails. So you must plead then that the vessel has sunk. And there is like in every, like now talking from lawyer to lawyer, there are of course pleading techniques how you can still continue to live without a bad conscience. And this is, for example, you would literally, under German courts, you don't say the ship was sunk, but you would say client is asking to plead that the ship is sunk. And everyone knows that you have severe doubts about it, but you must plead it unless you know positively the opposite.
Yes, but just going back to this example, it's a fact, the ship has sunk. The question I'm asking is, because I understood from Claus that in fact you could admit evidence. So can you omit the evidence that the ship sank because it was in fact scuttled?
Because it was a contributory factor?
Well, it was the cause of the sinking.
It was the cause. If you're clear that it's the cause, then I would have some doubts whether you can maintain this, because is that already fraud?
I don't know, I'm asking you.
That is the other line of it. Always, if it becomes a criminal offense, then of course you're not allowed to do that. So if you do that with a fraudulent intention, then you should not be allowed to use it.
Thank you.
Two more questions, perhaps, before we conclude.
On the witness preparation, I think when I saw the subject of the talk today, I was quite well, surprised that one can go to the extent of preparing the witnesses, and which is witness coaching basically. Because about 20 years back, an Italian lawyer did tell me that he's not allowed to interview witnesses. If he did that, he will end up in jail if he's caught. So it is a very serious offense in Italy. I don't know whether that is still the situation today. Now, when it comes to witness coaching, and I'm speaking from the point of view of construction industry disputes, you know, you get mountains of documents when you are arbitrating a construction industry dispute. And then you've got witnesses coming for maybe 10 days, 20 days, sometimes even more. And at the end of the day, at the end of the hearings, you get submissions. And generally, my experience is that the oral examinations do not constitute more than 5 to 10% of the evidence in the final submissions. The bulk of it still comes from the documents. So I believe that one should be economical on even witness statements, written statements, and then the cross-examinations and re-examinations that follow. Because a lot of it is unnecessary. You will find in the final submissions a lot of extracts, citations from the, you know, I would say tons of documents which have been submitted as evidence, contemporaneous documents.
Yeah, Mr. Ko, that totally confirms what I said before. You know, if you have documentary evidence, there might be no need to hear a witness, and then you don't need to address it anymore in your submissions, in your final submissions anymore. It's only helpful where really there is a contradiction of the facts and you have witnesses declaring something different. And then, of course, it is helpful not to rely on the written witness statements, but to hear them and maybe even to confront them. Yeah, this is the witness conferencing. Yeah, this is helpful in a lot of cases where you confront the opposing witnesses with each other, and then they should tell what they have seen on that and that day and how they behaved and what kind of arguments they exchanged and so on and so forth.
Okay, final question. Can I ask the final question then?
You are the master of the rules.
All right. We are not in Europe. We are outside Europe. So the rule or the agreement between the bar associations doesn't apply. Parties have not agreed to be bound by the IBA rules of taking of evidence. How do you resolve a conflict between two different national laws? One which allows for extensive witness preparation and the other which prohibits it altogether. So take, for example, an Italian party on the one hand and a Malaysian party on the other hand, and the arbitration is being held in Singapore, and that's the venue. I won't get into the question of the seat. I'll leave that quiet for the moment. How would one resolve this issue? Because these are very real issues that arise. And I think the point was made by you, Claus, that, or even, I forget, by one of you, that these are matters that should be dealt with at the outset. Parties' representatives should be aware of these issues well in advance. How would we resolve this issue?
Well, I think today we really give the Italians a hard time, and we can all be happy that no Italian is in the room. So, but the problem with the Italian, if I stick to your problem, is that this gentleman feels bound worldwide by his rules. So he can't act any differently. It doesn't matter whether he appears in Singapore or anywhere else. That's, I'd say, his particular problem. And the second point is, I think this is something that I dare say is an issue which we have to deal with every day in international arbitration, because different cultures and different perceptions of how proceedings should be conducted are clashing against each other. And the best solution to be found, I always think, is respecting party autonomy and, from the arbitrator's perspective, reaching an agreement on these issues. Specific problem with, I think, the aspect which we've talked about today is that I dare say, and no one has objected against the statement, that parties are not aware very often about the different approach in preparing their witnesses. So sometimes there might be a totally different preparation and perception of how you deal with your witnesses in advance, and it never comes up because witness just appears. The one is excellent, the other is not, and you draw a conclusion out of this without questioning to which extent have they been prepared in advance, isn't it? So, and otherwise, I think this is something, again, where I dare say this is another relevant topic which we all have to consider these days, where arbitration is under certain criticism. It is what I always advocate for is the courage of the arbitral tribunal to be ready to take a decision on all these aspects in case the parties can't reach an agreement on it. And then, in the very end, we all know how it works in practice. If you have an international arbitration with two common law lawyers as arbitrators and one civil law lawyer, depends always, but there's a tendency you will solve it in favor of a common law perception. That's how the cookie crumbles, and the other way around if you have two civil lawyers. That's our duty and our responsibility, offering the readiness to find a good solution and encouraging foremost parties to reach an agreement on this.
Nothing much to add. You know, as an arbitrator, you have to prepare the playing field, and that should give the same opportunities for both parties. And how you manage and being proactive, but first of all, identify the issue. That's the problem. If it comes up too late, then it might be too late, and then you might be subject to challenge or whatsoever. So address the things and provide the even balanced playing field.
So if I can just pin you all down to an answer here, how would you resolve the problem if you were sitting as an arbitrator in the specific example that I've given? Would you recognize the fact that the Italian lawyers, there are prohibitions would you recognize the prohibition under Italian law, or would you just disregard it?
Well, first of all, if there is a national regulation regulating one council, this probably would not impress me very much, because as I have indicated, I just think this is the party's pleasure to choose freely your council. And if you choose a problem yourself, self-made problems, then you should solve it self-made again. And to nail me down, how would I solve it? I want to be seen as someone who's ready to take decisions and someone who serves the goal of efficiency in arbitration. So the open question I would ask myself is to say, how do I serve the parties with regard to efficient procedures? And there's a tendency, as I said, being familiar to some extent with the common law system and with the civil law system, I would not even dare to say I do it the one or the other way, but just if I had to decide, I would say what is necessary to ensure that I can render an enforceable good result in the shortest time possible. I hope that... I
think that does, yeah. Thank you very much. I think, first of all, on behalf of everyone here, a big thank you to both of you. Can you join me, please, in thanking them the usual way? Big thank you for keeping us entertained for the last 1 hour and for so gamely taking on all the questions that have been posed. And I'm sure the both of you would, in turn, like to thank everyone here for taking the time off to be present and to have stayed till the very end and to have ensured that there's a lively discussion to bring this to a happy end. So thank you very much. Thank you very much. Yes, I'll pass you back to...
Yep. Before we conclude, as always, can we call upon Dr. Professor Sundaraju, the Director of KLRCA, to present tokens of appreciation to our excellent presenters this evening. First up, can we please put our hands together for Mr. Claus Lenz. And our second speaker, Mr. Rouven Bodenheimer. And our moderator this evening, Mr. Sudharsanan Thillainathan. Thank you, Dato. And if I could just take like a few more seconds just to remind you, upcoming events, this 31st, CPA Talk in KK. If you've got a colleague in KK, let them know. And next up, we've got the KLRCA Adjudication Training Program. If you register now and make payment within the next 7 days, 10% discount is yours. And last but not least, in January, the big decal course, the International Commercial Arbitration, places are going quickly. Please book your seat and make payment. And that note, thank you very much for this evening. There's tea, there's wine, there's food. Please do ClearBank Network. And take care. We'll see you soon.